วิดีโอนี้แม่นสารจำลองระหว่างฝ่ายองค์การอัยการและฝ่ายนางน้อยแสงสวงในกรณีการฆ่ามนุษย์แสดงโดย
All rise. The Honorable Judge Ajer Bouidi is now presiding the court hearing to hear the case against Ms. Noi Sensavong.
Thank you. Please sit down. The court hearing is now open. Mrs. Noi Sensavong, we are here today because you were arrested the 29th of September 2019 after making a confession to the authorities of Savannakhet. According to the order of prosecution issued on January 12, 2020, Mrs. Noi Sensavong, you are charged with prostitution. I would like to present and to explain their role to you. Firstly, my name is Ajer Bouidi. I'm the judge. My role is to decide whether you are guilty or not after hearing all the evidence. My clerk, Mrs. Perrine Simon, administers the court hearing. Secondly, here we have Mr. Lawrence Siri from the prosecutor office who would have to prove the charges against you. And standing next to you is your attorney, Mr. Max Muller, who will have the opportunity to defend you. Mrs. Noi Sensavong, have you been informed of these charges?
Yes. My name is Noi Sensavong. I was born on 12 of May 2000 in Savannakhet province, Lao PDR.
What is your profession?
I am sick and cannot work.
Mrs. Noi Sensavong, can you explain to the court where you have been in 2019?
I was working in Khom Siang in Ubon Ratchathani province of Thailand.
Do you have family in Thailand?
No, I was there alone. All of my family stay in Laos. I went there to send money back.
Mr. Siri, could the prosecution tell the court why it believes that the defendant was prostituting herself in Thailand?
Yes, Your Honor. The charge is based on the defendant's own statement of September 25th, 2019, wherein she admits that on March 1st, 2018, she entered the Kingdom of Thailand via the second Thai-Lao Friendship Bridge, where she voluntarily took up employment at a karaoke bar in Khong Cham in Ubon Ratchathani province as a waitress and as a prostitute, offering her sexual services for payment. Her statement indicates that she left her employment only after a year, and she paid someone at that time to illegally ferry her back across the Mekong River to Lao PDR. This is evidence indicating that she was paid for her services. Evidence of her voluntary nature can be drawn from the fact that she remained at Mrs. Anong's employment for a year before illegally paying someone to smuggle her back into Lao PDR. Her statement is contained here, Your Honor, in Exhibit 1.
Thank you, counsels. Counsel Muller, does the defense wish to reply to the prosecution's argument?
Yes, Your Honor. I have to point out that the accusation is solely based on my client's so-called confession. I will explain later why. The confession is not valid. But at this stage, it is important to note that the prosecution is interpreting the so-called confession and distorting the facts. It was never the aim of my client to go to Thailand to prostitute herself, but she has been forced to do so. She is a victim of human trafficking.
Mrs. Noi Sangsavong, why didn't you run away before?
I was not able to do so. Mrs. Anong, my boss, took my passport away.
Mr. Siri, did the police investigate the allegation of human trafficking as raised by the defense?
No, Your Honor.
Has there been a request for an international investigation to establish the facts of prostitution abroad?
No, Your Honor.
So the prosecution only relies on the defendant's confession, is it right?
That is correct, wherein she admits that she was a prostitute.
Does the defense have any submission on this evidence?
No, Your Honor, not at this stage.
Counsels, are there any other information and evidence to propose?
No, Your Honor.
No.
Then we shall move on to the debates. I would like to invite the prosecution to present his arguments as regards guilt and criminal liability of the defendant.
Your Honor, the charge of prostitution as a violation of Article 260 of the Penal Code is uncontroverted and established by the defendant's own statement of the 25th of September 2019, wherein she admits that on March 1st, 2018, she entered the Kingdom of Thailand via the second Thai-Lao Friendship Bridge, where she voluntarily took up employment in a karaoke bar in Quang Cham in Ubon Ratchathani province, as a waitress and as a prostitute, offering her sexual services for payment. In her statement, she indicates that she left this employment after she saved up some money, at which time she paid someone to illegally ferry her back across the Mekong River to Lao PDR, indicating that she was in fact paid for her services. The fact that she did not make sufficient money in her chosen profession is immaterial to the charges, as she voluntarily entered the services of Ms. Anong, based upon her own admissions. Further evidence of her voluntary nature can be drawn from the fact that she remained at Ms. Anong's employment for a year before illegally paying someone to smuggle her back to Lao PDR. The court should accept the voluntary statement of the defendant as reliable. First and foremost, because the defendant went herself to the police headquarters to report her working conditions to the police. There is no evidence that the statement of the defendant is unreliable or untrue. There is no allegation or evidence that the admission was obtained as a result of, quote, deception, force, threatening, beating, or other action which is prohibited by law, which is the provision that is prohibited by Article 36 of the Law on Criminal Procedure. Further, the voluntary statement is corroborated by her absence from Lao PDR for the period of a year and her medical status. This statement is therefore sufficient to secure a conviction of the defendant.
นอกจากนั้นอัยการซีรียังกล่าวตืมอีกว่าอิงตามมาตรา260ของประมวลกฎหมายอาญาองค์การอัยการได้ร้องขอให้ศาลตัดสินให้จำเลยจำคุกเป็นเวลา9เดือนโดยมีโทษปรับใหม่อย่างต่ำ 500,000 กีบเนื่องจากคำให้การที่เป็นประโยชน์ต่อคดีของจำเลยคำตัดสินดังกล่าวจะสามารถรับใช้เป้าหมายของมาตรการในการยับยั้งและก็ยังแสดงความเห็นอกเห็นใจต่อกับสภาพเงื่อนไขทางด้านสุขภาพของจำเลย
Counsel, could the defense give its opinion, please?
Yes, Your Honor. Well, once again, the law must be applied. Failure to do so, there must be procedural consequences. Again, I believe that the charges are to be dismissed. The prosecution presents the case as if my client would have made huge benefits with this activity. I need to insist that my client has been forced to provide sexual services. Do you know what my client has earned from this activity? The only thing she earned: a death penalty because she is sick, infected with deadly diseases. It is time to recognize that my client is a victim of human trafficking and not the criminal who made huge profits. Unfortunately, the policeman did not investigate the crime of human trafficking, but focuses on the charges of prostitution. According to Article 36 of the Law on Criminal Procedure, all confession from the accused person or defendant will be rejected if there is some involvement of deception, force, threatening, beating, or other action which are prohibited by laws. Your Honor, you are confronted with a questionable statement of a weak person. After 7 long hours of questioning, the statement has been recorded by the police. The law provides that the confession is to reject because it has been obtained illegally. Thus, the defendant needs to be acquitted of the charge.
Thank you, Counsel Muller. Mrs. Noy Sengsafong, do you want to say one last thing?
I'm sorry. I went to Thailand. My life has been stopped since that moment, but I am not criminal.
Thank you. The court hearing is now closed. The chamber will retire to deliberate in closed session. Exceptionally, to serve the purpose of this mock trial, the judgment will be delivered extempore.
All rise. All rise. The Honorable Judge Hajar Widi.
Please sit down. After considering the case, the chamber comes to the following decision. The defendant must be released from charges since there is no other binding evidence produced by the prosecution in support of the confession made by Mrs. Sengsafong. Yet, Article 36, paragraph 2 provides that even though the accused person or defendant has confessed to their offense, such confession shall be officially used as evidence only if there is some other binding evidence has been discovered, respectively. The Chamber notes the absence of further investigative acts or MLA request to Thailand to find out if the defendant was actually working as a prostitute in Thailand. It's obvious for the Chamber's point of view that the investigation has been conducted incorrectly and incompletely. Therefore, on behalf of the Lao PDR, Mrs. Noy Sengsafong is not guilty of prostitution of Article 260 of the Penal Code. Thank you.